Testing, testing. Okay. So this thing is actually working, right? You guys can hear me? If you could just give me a thumbs up, I believe you can hear me. Um, I'm actually going to jump on here real quick while we wait to be let in. Make sure that you guys and you can hear me. Great. Apologize for the noise in the background. Um, so while we wait here, wanted to jump on real fast and talk about what George is trying to do over in Michigan because I think it would be beneficial to others. So currently, right now, George's daughter, or George and um, his daughter's mom, mom is primary, and his daughter goes to school in Michigan, and George is attempting to change custody to have his daughter basically reside primarily in Texas, go to school in Texas, um, and for all intents and purposes, just basically invert the current schedule. Now, a lot of us are in those situations where we want to try and obviously make a change within our current situation, and we don't necessarily know how. So, one of the things I wanted to do, I'm looking up right now um, in Michigan what the modification requirements specifically are for the state of Michigan. Ideally, you typically always need to have substantial change in circumstances is the the primary criteria. Um, and I'm taking a look here real fast, and that's exactly right. Same thing, right? So some of the changes in circumstances they illustrate here are if a parent's absent from the home, the parent has begun abusing drugs and alcohol, the parent's routinely not providing care for the child, the parent is abused or neglected, is are some examples that they give that would warrant um, even a hearing, if you will, right? That's the first threshold, and that's what George is trying to do today. He's trying to get over that first threshold of even validating that his request has merit. So he needs to demonstrate a change of circumstances, right? So he needs to have a particular reason, and even more so, he then going to need to show how the change is necessary for the best interests of the child. So some of the examples that they also give that do not qualify for a proper cause or change of circumstance is a parent's financial problems, a child's normal changes in needs as they continue to grow, and simply a child's desire to change custody. So, obviously, right, if a child wants to go with mom or dad, typically that would not warrant or pass over that threshold. Obviously, if there's other, circumstances, situations going on, that's a different story, but we're just looking at it basically at your kind of standard request. So, in short, we not only have to convince the judge or the court that the request has merit based on certain situations. We will see what particular reasons George is going to try to articulate that would warrant that, right? That would cross that threshold that a change of circumstance is warranted. A lot of times as well, you can take a look at the best interest factors, right? Remember, every state has enumerated child custody best interest factors that a judge must look at when trying to determine custody between the parents. Right now, we just saw with Florida, right, that although they passed the law about a month and a half ago, Governor DeSantis just signed it. a couple of days ago at this point. It goes into effect July 1st. Just did that TikTok on it. And in short, what that gives is it gives parents or dads starting to go into a custody battle the presumption. The judge has to basically assume that 50-50 is in the child's best interest. Another way to look at it is that 50-50 is the status quo. And the legal arguments from either parent now has to be, why is that not in the child's best interest? Which is completely opposite than what it used to be, right? Before, the judges basically had sole discretion to apply the best interest factors however they saw it fit. And now there's that requirement that the parents have to show through a preponderance of evidence why the best interest, it's not in the child's best interest to have 50-50. Okay? So it's kind of the same thing here, what George is trying to do, right? There's a status quo in place. So the way the court looks at it is in order for me to change this child's life, right? You're asking me to go in and alter this child's life. What good reason do you have that this child deserves for his life to be changed? And it goes a little bit beyond just what's within my right. I understand all those arguments. But just looking at it from the application of statutes and law and best interest factors, right? So George has to go and show, well, this is why, Your Honor, I'm asking you to change this child's life because of this or that. Obviously, if the child is thriving, doing well at school, not being abused in any manner, not being malnutritioned, has friends, involved in the community, right? That status quo, that reality that that child is doing okay, becomes a very, very high threshold for the other parent to come in to say, well, that should be affected because of this. Again, let's put the whole rights thing to the side, just from a debate perspective, from a legal argument perspective. So that's the first thing George has got to do. So we'll see what argument he has for that, what he's going to try to do within there. Part of it again, the judge looking at it here, right? Step two is the judge is going to determine what standard of proof needs to be applied. So same thing that's happening in Florida, just kind of the other way around, right? Typically, you're making a request for change. Well, what proof do you have that the change is necessary? Step two. And step three is going to be, how is that change in the best interest of the child? So it's three steps, right? It's requesting the change, proving why a change is needed, and then showing how that the change is in the best interest of the child. So once you now get into the best interest part, all the factors kind of open up again, right? So you may warrant that a change of circumstance has occurred. You may have proved that. And let's use the Florida 50-50 because I think it's a great example, especially that it's literally just happening in one of the main changes in there, which is this addition of um, this 50 mile section or rule that they've now included, right? So in Florida, they are now saying that, or it's now included in the new law or the update of the old law, really. But they are now stating that if at the time the order was initially created, if a parent lived 50 miles away from each other, but since that order, the parent has moved within 50 miles, that move by itself, is now considered a substantial change in circumstance. So, in theory, I'm a dad, right? When the order was created, I, was living in Miami and mom was in Orlando. But since the order, I've gone and I moved, near Orlando, Kissimmee, wherever, within that 50-mile radius. I can now go into court and say, Your Honor, I'd like to apply or I'd like to request a modification of custody. And I want to get 50-50 because I now fulfill that requirement that I'm within 50 miles. So we've gone ahead and we've satisfied, right? The first step, identify, what that change is. The second, proved that that change occurred. So I'm going to go ahead and submit my lease, right? Some bank statements, some utility statements, whatever the case is, to prove I'm within 50 mile. But now we go to step three, which is okay, now we got to apply the best interest factors to the scenario. So just because you're now within consideration of 50-50 does not guarantee you get 50-50. It's merely the fact that you're now under consideration. So they're now going to look at all the best interest factors in Florida. Same thing here, right? So if George is able to convince the court that a change of circumstance is warranted, and he proves that, the judge is then going to say, okay, fantastic. Now let's go ahead and let's apply the best interest of the child factors. And why does the court want to do that? Well, in our example in Florida, okay, so dad has moved, let's just say, within 15 miles, right? But he may not have the availability to have 50-50. Or maybe, some of the financial requirements are maybe he's hostile towards mom, right? Maybe they're always fighting. He's never promoting, the relationship on mom's side. So all those factors now come into play. And if dad fails on any of those factors, well, then 50-50 is probably not going to be granted. And maybe some change in parent time will happen. But the application of the best interest factors is what becomes so critical. So if we take a look at it, we're still here, we're still waiting. So I'm going to click on the best interest factors here for Michigan. Michigan, actually, we talked about this the other day, I believe, with one of the other dads, right? They have 12 factors. The 12 factors range from factor A, and let me go ahead and I won't share this because I don't know when we're going to get into the Zoom. So factor A, which is the love, affection, and emotional ties that exist between the parties and the child. Factor B, the capacity and disposition of the parties involved to continue to provide guidance and education to the child. The capacity of the parties to provide the child with food, clothing, medical care. The length of time the child has been in a stable, satisfactory environment. So this factor becomes a little tricky because, right, a judge, although you're not being considered for 50-50, can come out and say, yeah, but the child's doing, well in this environment. I'm not going to go ahead and affect that. Factor E, the permanence of a family unit. So how long have the parents been there? The moral fitness of the parties, the mental and physical health of the parties, the child's home school and community record, the reasonable preference of the child, the willingness of the parties to facilitate and encourage relationship with the other party, domestic violence, and any other factors the judge considers relevant. So what that means is basically what? That even though we have the opportunity to get 50-50, it doesn't necessarily mean that 50-50 is going to be granted or that it's mandatory. So we still have to take a look at and make sure that we're complying and satisfying all those child custody factors. And again, every state has enumerated child custody factors. You can just type in your state, then child custody factors, and that'll come up. Or you can type in your state, it's a family court modification of custody order, and you'll get some of those requirements that'll come up. So, while we wait here, we're going on almost half an hour. We'll see what we do here. I may do the same thing I did um, at our last hearing with John last week, which I may just come off here, and then if I'm able to get into the Zoom, just then quickly jump back on and and show that. But just wanted to give a little more context, especially on the modification side, for those that are looking to possibly get, file something like that. All right, talk to you guys soon.